So good afternoon, my dear members. I am Dr. Prashant Sarangi from ICSI IIP. So welcome to this webinar. And today we are very fortunate to have Dr. ASHOK MISHRA sir, former member technical of NCLT. So in advance, I want to say that, sir, thanks sir for accepting our invitation and sharing your valuable experiences with our members. And I'm sure that my members will be benefited out of your experience today. So I hope that this session will be one of the learning and one of the interactive session today. So I request Anjali to introduce Dr. Mishra sir with his brief profile. Anjali, please.
Yes, sir. Good afternoon, everyone. Good afternoon, ASHOK, sir. I welcome you all to the webinar on the topic Sharing Life Experience by a technical member of NCLT and NCLAT. Today we have with us ASHOK Mishra, sir, as a speaker. Now let me briefly introduce Sir. Sir is having more than 40 years of extensive professional experience across various levels of central and state governments, including quasi-government entities in accounting, finance, contract management, leasing, and legal domains. He retired in 2023 from the role of technical member of NCLAT, Principal Bench, New Delhi, on elevation from technical member NCLT, Bangalore. He is the Government of India nominee to Central Council of ICSI. He is also serving as independent director on board of ICI Registered Valuer Organization. He is also distinguished fellow member of IICA Ministry of Corporate Affairs. Now I request sir to start with his session.
अच्छा इनको ये ठीक है some of the faces I feel some of you may have appeared before me. First of all, good afternoon to all of you, and learning from the current institution, salam alaikum to all of you. So I am first of all thankful to ICSI IIP who has given me this opportunity to come before you, and maybe I will learn more from you than what I will give you. So with this, let me start, and I can only tell you about my experience, personal experience, both as NCLT Bangalore member and to a very short period at additional charge of NCLT Mumbai, and then NCLAT Delhi, Principal Bench Delhi. Since I am a researcher also, basically PhD in finance and Doctor of Law from National Law School, Bangalore, apart from being a chartered accountant, so I have done some very petty small scrutiny how my fellow colleagues, insolvency professionals are in the today's atmosphere. So I will like to share with you, first of all, some of the input, which really a great emerging input for all of you, as all of you has helped the nation in bringing to the mainstream around more than 12 lakh crore. More than 12. Oh, good afternoon, Sarangi Saab.
Good afternoon, sir. I'm there.
Okay. So you all insolvency professionals, whether from ICSI, ICAI, or Bar Council of India, all of you together has helped the nation to bring around more than 12 lakh crore rupees. And in a annual budget of the government of India is 44 lakh crore. So your contribution is around 26-27% of the annual budget as a figure I am telling you. Then second thing what I can tell you, people will tell so many things about you that these cases are pending in IBC, that case is pending. Approximately 1,000 cases as of today, maybe 947 resolutions plan have been approved, and it has on an average realization, although there is some difference of figures also, but it is marginal. 27 to 32% of is the average recovery rate with reference to the admitted claim. But if you go by the liquidation value, which is the real evaluation parameter for a sick company, you have helped the nation to recover more than 162 to 165% against the liquidation value. So, and secondly, now the trend has also increased. Earlier liquidations were more, around 80%. Now from 2017-18, I have collected some data, 2023-24, our resolution as a percentage of the total disposal or total cases filed was 21% in 2017-18, 2023-24, it has even come up to 61%. And if we go by the other side of the data, what the banks are doing, then all of you have done far better than the bankers. Bankers in the 5 years have written off 9.90 lakh crore, against which the recovery is 1.84 lakh crore. So their recovery rate is virtually, in my opinion, it is even not more than 20-25%. So as insolvency professionals, you all are doing marvelous job. Whereas I am pained to point out that I have only gone through some disciplinary reports, and I am pained to hear that my professional colleagues, all insolvency professionals, I think 203 inspections were done. Out of that, 123 IPs have been are the victims of some penalty, and that too on petty issues related to Section 29A, Section 24. So, and even in some of the cases I have found, it is not anybody of normal prudence will do the same which as IP you have done. One case, I don't want to name that case, that was disposed on 14th August. That was relating to non-filing application for avoidance transaction. That is the transactions which are covered under Section 43, 45, 50 and 66. The IP has done one of the best thing, that he filed finding that COC has not approved. COC has not approved the Forcenic audit report. So he did a good job. He filed an FIR under the he filed an FIR with the CBI. I don't know what wrong he did, because filing before the adjudicating authority, okay, there is a provision Regulation 35, capital A of the IBBI insolvency resolution process for corporate process, Regulation 2016, read with section 25, subsection 2, clause J of the code, simply says that you have to file with the adjudicating authority. But suppose if the COC is not holding the hand, who is supposed to bear the cost of this? I don't know what is the mistake IP has done. So, but I can tell you as a man of finance and being the Director Finance and CFO of largest defense company of India, that is Hindustan Aeronautics Limited, on the face of the reading of input, I only found that sometime some of you get into some problem, in my opinion, even without your this thing, even with the best precautions that you are taking. So I will not dishearten you on this count, but I have found few cases. Another case was that may be a slight mistake in 29A, capital A, although because sometimes what happens ki as a resolution, because sharing, I am presently sharing with you all the input, whatever small petty research I have done. Then I will come with my experience, and at a later date, after some time, then I will be open for questions also. Now, what I have found in this case, section 29, capital A, only provides that the MSME are granted certain special benefits under the code, or certain provisions of the code they are exempted from. But okay, one thing always we will have to keep in mind of related party involvement. Related party involvement thing, that as a member of the quasi-judicial body, I will always request all of you, whether the law provides for this or not, I don't, I can't comment exactly on that front. But as a man from that field, I can always tell you that always take some time or some type of affidavit from this resolution applicant that they are not or their involvement does not attract the provision of section 29 capital A of the IBC, because you will try to link it, but sometime in a pressure of work, when you are handling multiple tasks, you will find that you may miss some small issues. So what happens, sometimes it is not very clear, because related party law defines in one way, interpretation is in a different way. So sometimes we may miss. So it is always better to have some type of affidavit affirming the solemn faith that they are not attracting 29 capital A, particularly from the managing director or a director of this, that type of thing, including from the resolution applicant, if it is possible. Suppose if I know board is under suspension, so CD directors have no value, but virtually from resolution applicant, you can take this affidavit, Solomon affidavit, that section 29A mentioning, not only just referring section 29A, whatever the section is telling, maybe in the form of annexure, but you must mention that they are not attracting any negativity or any attraction towards this particular section, because this seems to me a borderline case. That was one case, and it is not only happening with ICSI or ICAI. It is in general happening with every cases they are doing it. Particularly, both the institutions are highly affected by this approach. Then I have also, and sometime reprimanding, whenever there is a reprimanding or any type of adverse comment from NCLT or NCLAT, you will have to take committee of creditors into confidence and always go for an appeal. Because what happens, these fellows sometimes they are not understanding the criticality, or maybe they have not been conveyed like that. Or you can do it differently. Whenever there is a colloquium and some of you get an opportunity to speak for, then you must speak that even a slightest use of adverse comment from them unnecessarily put you in the bracket of IBBI, that disciplinary authority issues. So you can always mention this issue at that time whenever you observe that there is any adverse comment, or sometime in some format you can see even the IP is as an insolvency professional, you all are an officers of the court. Your advocate can't meet members, but I think meeting IP insolvency professionals, I don't think that it is very adversely taken by some member. I don't know. From the judicial side, there may be some issues, but otherwise I don't find that you can't meet, because sometimes these fellows are also in a hurry-burry of disposals, so you become the victim of the situation. Sometime I have seen in one case, one ICSI IIP was you were the member, one of you were the member in ICSI IIP. Now, comment like this, non-cooperation during conduct of inspection. Now, first of all, attracting such an unnecessary punishment, I don't think this is also an area to be reviewed. I don't know. In any case, after addressing you, for the purpose of addressing you, I have gone through some detail, and I will also speak to the concerned members, and also will convey to the chairman IBBI. Because you see, if some letter has come in the month of December, and you have responded or you have provided all the information by 10th January, if my memory is correct, I don't find it can be more faster than this. Then how they can take it adversely for one of my fellow colleagues? I don't understand. So then certain things I have also seen, like when you are dealing with, when you are sometime, इतना जल्दी चाय तो बड़ी जल्दी लाता है ये
तो बाद में दूसरी मंगा लेंगे।
हाँ बाद में दूसरी पानी ठीक है पक्का ना you are a company secretary
No, sir. We both are lawyers. LLP.
both are lawyers, they keep lawyers.
No. Actually, we have done LLP.
इसको ये कर दो.
I have done CS executive. So
No.
take a break for 5 minutes, agar, if you want to have tea.
टी तो ले ही लेते हैं.
So we can break for 5 minutes.
कैसे करते हैं टी को?
We'll take a break for 5 minutes and then resume in 5 minutes. Thank you.
Audio, okay?
हाँ.
So what I was mentioning, because luckily ICSI IIP has also got advocates with them who are the integrated 5-year law course graduate. They can also assist you in this thing if some of you feel necessary, because all of us may not have the same awareness which some of the colleagues may have. So it is always better. That is one of the experience which I felt that is not very healthy trend, because any profession these days, one approach no doubt I am finding in the current atmosphere, because the regulatory authority on every professions are slightly taking adverse stand even on a slightest deviation, which I feel as an individual, and which being an independent man at the moment, I can tell you that certain aspects needs to be taken due care by all the agencies. Suppose if you have, and suppose if somebody has done some audit, now he has qualified the audit report, but still he is giving true and fair view. These days, regulatory authorities are also questioning them that why you have given true and fair view. You should have fully qualified the account as not reflecting the true and fair views. This is the general trend I am telling you. Now, in your cases also, whether it is section 29A or section 24, I am another thing finding particularly that be cautious in a job where there is a change of IRP to RP, RP to RP, that type of job when any one of you are taking up, because nobody can force a particular job on you in the true spirit. So whenever you get some assignments like this where there is a multiple change of IRP to RP, RP to RP, at that time you should be more cautious in that case. Don't go by any personal influence, whether it is the influence of Mr. X or Mr. Y. This can always bring you in some type of complications and problems at a later date. My study of 5 cases, particularly 5 cases I will not name, in the month of August 24, wherever my colleagues as insolvency professional, some of you have been awarded adversely. So I am finding mostly the cases crops up in the case where there is a change of IRP to RP, RP to RP, RP to liquidator. And we take up the new assignment being very happy we have got one more assignment. But I feel that cases out of 5, if you ask me, what I have studied, I have found in 4 cases this type of issues. So friends, our brothers and sisters, my request to all of you that whenever you find in a case there is a change from IRP to RP, RP to liquidator, this type of thing, then or liquidator to liquidator sometime in one case, be very, very cautious. Don't go in a very super fast Rajdhani Express train or Duranto Express. Kindly see all the papers, whatever the details he has given you, whether he likes it or he does not like it. You must collect all the requirements, handing over, taking over, whatever is the system prevalent in your profession, which I am not exactly aware. Kindly create proper document so that the blame game should not happen, and you also should not accept an assignment where they have get themselves involved like this. This is another note of caution. Then my one thing was also there. Some of you are very fashionable to going for forensic audit. forensic, and then at a later stage, you yourself says that there are several gaps in forensic audit report. Now, same thing is being told or mentioned by the COC also. And then what the disciplinary authority is doing, your intention is correct, you have done everything correctly, but the disciplinary authority feels once you have done the forensic audit report, why the matter has not been, why a petition has not been filed before the adjudicating authority. So, I feel, and my personal suggestion is that it is because you can know from looking at the books of accounts or from the records of the CD that apparently whether there is any lacuna or not. Because now being a professor in a school of law at Delhi, I can tell you forensic audit report itself is always questionable. Because if somebody has not the data, then it is a presumptive figure. And presumptive figure has no basis for filing a case. Because IPs are not, in my opinion, they are the officers of the court, but at the same time, they are not the investigating agencies and they have not been trained and tuned to be the investigating agencies. So how he can find out the gap and presumptive figures he can give, like you are all also aware that in some of the scandals, some such presumptive figures were pointed out, and lot of people from top to bottom were in difficulty. So, don't hurriedly appoint some forensic auditor and put yourself in difficulty unless prima facie you feel there is some irregularity. Otherwise, we do half job and lands ourselves into trouble, because there is a difference between an advocate, an insolvency professional, or a chartered accountant or a company secretary. Because we are professionals, we are not expert investigators. Even if you ask me, maybe the forensic auditors are also giving some certificate, and based on that certificate they take up this, becomes the forensic auditor, this by complying some petty requirements. But it is a specialized area. None of us are so trained and tuned that we can find out the reasons for the gaps immediately. Prima facie, whatever the provision explicitly say that within 2 years any such transaction will be presumed to be adverse, or within 1 year with related parties to be treated as adverse, wherever the sections are pointing out from 43 to 66, those things you find out the transactions. What are the transactions? Transaction, how you can go see the bank statement, where whatever is the large figure, whether it is in the receipt side or payment side, you have to check up those figures last 2 years maximum, and then you can find out what is the trend. When you prima facie feel that there is some strong reasons, then go for that. Otherwise, you all are trying in the national interest, and you are getting what from disciplinary authority, these types of assessments. Being a professor, I am telling you as a professor of law and both law of management, I am telling you. So, my study only suggests that you avoid unless you find major gaps apparently. Then
Ashok,
I have
Ashok
also
sir?
told, because
Ashok
some of
sir,
the orders I felt.
can we take, if you'll permit, so can we take some questions?
Network questions I will take. I will give them something. Okay, kindly tell me the problems. First thing I will take problems then.
Yeah.
Dr. Rao, you can also tell me, others can also tell me, no issue. Today you all are in the member's chair. I am in your position as advocate. So you can raise questions. I will try my level best to answer.
Thank you. Thank you. So, BB Ramesh sir, please ask your query.
Yes, sir. Am I audible? Thank you very
Yeah,
much.
absolutely.
Good
Yes.
afternoon to all the participants and the Honorable NCLT gentleman who is giving us a beautiful lecture. I would like to place on record that we are all enlightened. I want to just say that he was touching upon the role of IPs. Our IP is another tool in a bigger game, because IPs must be free to resign if they are not happy. This is a democratic country. Why should we have rules which don't permit IPs to resign when they don't like an assignment? If I take a job, I must be free to resign. That is point number one. And secondly, recent guidelines gave the COC powers to supervise IPs. Is that how correct is that? When the IPs have the entire IBC code has come into force in 2016, keeping in mind that previous insolvency resolutions, winding up provisions under the Companies Act have, and even the SIC Industrial Provisions Companies Act have not really yielded adequate equilibrium results. IBC is a kind of a hybrid legislative law. Under such circumstances, why should the IPs be subservient to the COCs? That is my primary question. Why should the COC exercise supervisory powers? That will tantamount to reducing the powers. It actually makes an IP a clerical auditor. It doesn't give, under the IBC code, as I understand, there is hardly any decision which an IP, a registered IP, can take independently without the approval of the COC. Why should that be so? Because we have traversed a long distance to arrive at this IBC code.
Yeah, Ramesh sir, we understood your question. So,
Yeah.
Mr.
Why
Sanjay.
should-
Now, Mr. Ramesh,
Thank you.
thanks a lot.
Thank you.
So today here I am not as a technical member, National Company Law Appellate Tribunal. Today I am appearing before you in the role of a professor in a school of law in a university, one of the largest deemed university of Delhi. What I personally agree with your view on the IBC hybrid code, and you are talking about supervisory power of COC or supremacy of COC over IP. It is not that I do not agree with you, but you know, COC has been given a role which has been confirmed by basically by the judiciary also, that all commercial decisions, they are the supreme. They are having more powers than even adjudicating authority and appellate authority. So this blind power given to COC as owners is a matter of question. Blind powers when you give to an authority and you are expecting a compliance from a professional who is not an independent decision taker is an area which some of you are free to point out the parliamentary committee, because the recent report of the 67th parliamentary committee report, which was submitted on 6th February 2024 by Honorable Member Jayant Sinha, because somebody should have pointed out this report, because he is also commenting not very favorably on this cadre of professionals. So it means that we all insolvency professionals must present these views before the Parliament committee, because it is the Parliament which is the law framing body in this case. By telling to the government, government is a party for a law making. But yeah, if the parliamentarians are aware about you, you can even speak for, or you can, I don't know how, but there are committee, there are ways, and you have got one of the most dynamic managing director like Mr. Prasant Sarangi with lot of connections at high level. So he can assist you in this, take his help, because everybody to grow needs some hand holding. I totally agree with your comment on COC, but how, and I am also agreeable that when we have in the background of mind our recovery rate was not more than 15%, 6% is the recovery rate in the Lok Adalat. Whereas in these types of Sikha and other tribunals, that is Sikh industrial companies and other, the recovery rate was not more than 15 to 18%, less than always 20%. Now, with those failures, we brought the IBC. We brought a cadre of professionals like insolvency professionals. So I totally agree with you. This is a gray area, but you know, बच्चा जब तक रोता नहीं है, माँ भी उसको दूध नहीं पिलाती है. So you all will have to take the leadership of Dr. Sarangi, take advantage of this. Secondly, you have also mentioned to me free to resign. I agree with you. I am not telling why you should not resign, but I have not touched upon that subject, that why you should not resign. But when a new person is taking up from the earlier resolution professional, he should be also equally careful. If you have resigned, say I was working, I have an assignment of Mr. XYZ Company Limited. Now XYZ Company Limited was having an insolvency professional, Mr. B. Mr. B was an insolvency professional of XYZ Company Limited. Mr. B has resigned. Now from somewhere Mr. P has come and he is showing extra interest. I don't know. He has taken up the assignment, and in the bargain, today or tomorrow, he is likely to be in difficulty. Why? Because if a person is resigning, have you taken a note from him, signed notes? What are the gray areas? What are his observations on those gray areas? Why he? Because as a professional colleague, when we say take NOC, even a chartered accountant auditor, when from say Anjali to Anuradha, she is a chartered accountant, the other is also a chartered accountant. Say Anjali is resigning from particular company as an auditor and Anuradha is taking over that assignment. Then she has to take the NOC from the others. I don't know how the system prevails here, because when you are taking over that, you should also collect the note from him, which should be in writing, that what are the gray areas which were difficult for them to manage, and that's why he has resigned. Free to resign is one thing. Always it is permissible. No law says that you can't resign. Even I have seen in the tribunals, advocates leave the job. Okay, some cases they they are surrendering the assignment on the ground that the party is not making payment to us. What the tribunal used to tell, you have to pay to the party. Other person, and then only he can give you NOC for the other advocate, because BCI regulation talks like that. BCI means Bar Council of India. Their regulations talks like that. It is not that aap chhod denge wo le liya. Secondly, also, you always resign, but you, to your other professional colleague, you always give a note of caution. Because note of caution we are not taking up, we are simply accepting an assignment. I'm telling you from my personal life, both being a director finance of a company where one director was behind the CBI bar, CBI, and another director has to leave the job prior to his term ends. So I worked in that type of company. Then naturally, I will suggest you based on my life experience that be cautious. Something is to be done. Then also you have mentioned about the power to supervise. This is, where is it specifically written that IP COC is the controller of IP? I don't think that anywhere it is written. What IP is to take, like the managing director of the company has to take board approval for certain things. For some approval, they have to go to the shareholders. Correct? So
May I
in
come in,
this,
sir?
say,
Sorry for the interruption.
no problem.
Can I
Mr.
come in?
Ramesh, suppose
With your permission.
Ramesh sir, let Dr. Mishra sir speak.
Okay, sir.
no,
Okay.
you can go. Ramesh want to speak. Okay, Ramesh,
No,
kindly
you
tell
asked me. You asked me a question, sir.
No, I have not asked. What I am telling you, supervision power, what you are telling that is specifically the question of supervising powers. I am telling you differently. COC, for any proposal, you need the approval of COC. This is the basic general understanding. Whether it is with 50% voting or 76% voting or 66% voting, forget about the percentage. But you have to go for some acts or from somewhere even 90%. So I am telling you differently that even the managing director of the company will have to go to the board for approval of his certain proposal, or for shareholders for certain other proposals after taking the board of directors approval. Similarly, in your case, it is the COC to whom you have to approach, say when you are selecting a resolution applicant, because the gray area where COC power in some format, even the judiciary has confirmed at the apex court level. So this power is only vested you, but they cannot tell. Suppose if the COC decides or tells you that you do a particular job in a particular manner. Says, suppose COC has some way they are influenced by the CD, past CD management. Now, even if COC wants to help them and they want to propose, they suggest you to take a certain course of action, you can always refuse. But refusal must be as in a written format. You must refuse, get it recorded. You are recording the minutes, COC minutes. You are circulating draft for approval. In the minutes, please cover that aspect, because all of us know, based on our experience, that you can smell a rat once you see the trend of the people, how they are operating in a COC meeting. So if you find somewhere something is there, I don't find it is like a case in an organization where COC is filing the annual confidential report of the IP. They are not writing your annual confidential report. So you are, in true sense, you are not reporting to, you are a mechanism who is presenting to the COC with the facts and status of the case or the proposals. So you are not subservient or in any case junior to COC. COC has a different power in a different line. You are a legal authority. A legal person will always have an assertive right, and he can always assert on that issue if he is finding something is wrong. Your job is only to point out what are the deficiencies and to work in accordance. Am I clear? Anything?
Yes, sir.
If I have
Thank you,
forgotten.
Dr. Mishra sir. Thank you. Ramesh sir, if time permit, then we'll give you option. Thank you.
Thank you.
Then
Okay.
Ravi Shankar sir, Please raise your question. Ravi Shankar ji.
Good afternoon, sir. Thank you, sir, for giving me an opportunity.
Yes.
Sir, I am from Bangalore. I don't know whether you can recognize me with my this one.
No,
Sir,
no,
my
from
question.
your face,
Right.
I recognized you.
Right. Sir, this is like one question, sir. There is an appellate authority in the IBC proceedings, which is NCLT.
Pardon, 1 minute. I missed it. Tell me.
There is an appellate authority under IBC proceedings, which is NCLAT and the Supreme Court.
Correct.
But what is happening is that many cases are going to High Court and they are taking a stay there after admission. So what is also happening in the process is that the RP who has been appointed, he is stuck neither here nor there because we can't appear before High Court as a RP. At the same time, if I engage an advocate and we don't know what will happen, ultimately we have to pay fees because before NCLT or NCLT, I can appear and I can argue also and present my case. But in the cases where it is going to High Court for a stay, we are stuck because one is that I have a limited number of cases that I can take up as an RP. And this case is always showing like I have one case with me. At the same time, I am not sure whether I'll get a fees or not for this kind of an assignment for this stay period. Though I am still in some cases, I'm continuing to discharge some of the duties because there are IBA disciplinary cases which say that during the stay period, I'm not supposed to hand over the control back to the promoter, but I'm supposed to still monitor the proceeding process and all that. So your view, sir, how do I protect myself from at least the fees part is one thing. And what is that we should do in such cases where the High Court stays comes, which is outside the system of IBC? That's where we are stuck, sir.
You see, perhaps as a member, I could not have been in a position to tell you, Ravi Shankarji, but as a professor of law, now as a professor of law, I can tell you, because constitutional power of High Court, Article 276, all those Janjat are much powerful than Honorable Apex Court power under Article 32, where they are touching only the fundamental right. Here, multiple writs, multiple rights are involved. So, High Court has a very wider jurisdictions. So, Honorable High Court thing, although in the chain it does not come up in the IBC, but nowhere in the IBC code, although IBC code has also mentioned that civil court have no jurisdiction. But I don't find that even the government has, in spite of so many objections from the people, that because of the High Court interferences in some of the large cases, the time consumption is going up and we are unable to maintain the 330 days time frame. But nobody is in a position to mention specifically it should go only based on the unity of command, that is adjudicating authority to appellate authority, NCLAT to Honorable Apex Court. Everybody, instead of approaching NCLAT, they are approaching to High Court. Even the government at some time informally, it was learned at some point of time that the NCLAT benches will also be all the Cosmo Metropolitan. But the Cosmo Metropolitan will also not serve all the purpose because we are a country of over 30 states. Every state has a High Court excepting a few. So either there should be a bench of appellate authority at every places. Otherwise, there the advocates already they have filed some cases that we have to travel a long distance for filing the cases. So we are taking shelter of the Honorable High Court. These are the reasons. That's why perhaps the government is also not in a position to decide. But your view is well respected. Kindly submit, and I know you that you are a strong, firmly you point out your issue. I know Bitanala period. So you are very firm in presenting your side of the case. So it is always better to appear before the Parliament committee. They are the persons perhaps you can think of otherwise, because they have also commented one of the purpose of Viswanathan committee report was low period of disposal, which is not happening. Most of the cases it is not happening apart from interlocutory application, basically because of the involvement of the high courts also, honorable high courts also. So that is a very gray area. Now, your fees are concerned, in my opinion, it is their job to pay the fees. Suppose if it is in High Court and it is taking time because of one reason or the other reason. If Honorable High Court is taking its own time in disposal, naturally, who will bear the cost of the advocate? Suppose if the respondent side goes unresponded, your disciplinary authority will tell why you have failed. So, and they will put some unnecessary punishment. Even a reprimand is a bad thing in law. So, in my opinion, you kindly take up this issue for the larger interest with the parliamentary committee. For the immediate requirement of your fees issue, you must take up through your you may take up through these companies also, where you are registered, whichever IP is registered with whatever IP agencies, that there through them, and also directly being a professional member of the Insolvency Board of India, you must take up this issue and tell them that their board should also discuss this issue, because in the IBBI board, because a particular section is there. Oh, isme to hai. I can tell you because immediately it is difficult to remember. There is a provision that IBBI board constitutes also a member from Financial Services Ministry, that is the banks, because basically banks are more involved. So if they give some direction to the banks, wherever the RP is involved and RP is asking you to take up the case with the Honorable High Court, let there be direction from Ministry of Finance that COC is to bear the cost of this in the proportion of their claim. You take up with the Financial Services Secretary, because they are bound to take up this issue, because it is their bankers. As far as my fake memory goes, 80-85% cases are where the COC is dominated by the banks only, at least in the voting power, even in the real estate sector. So in my opinion, you take up with them. Hopefully they will, you will build some stature where your successors will reap benefit of this.
Thank you, sir. Thank you, sir. Thank you, sir.
So thanks, Dr. Mishra, sir. Please proceed with your other experiences, sir.
No, anybody has any other questions, sir? They can ask. I have no issue. But I am now again going back. Now, I am telling only goody things to my resolution professional. Dr. Sarangi should also feel happy that these IPAs are doing great job for the nation. You see why there is a flux of heavy movement of fund into the equity market or mutual fund. The ET report of financial year 2024 points out that individual retail investors have invested 36 lakh crore. 36 lakh crore in direct equity and 28 lakh crore in asset management. 28 lakh crore in asset management. These funds have gone because in the background you all are involved, because you are giving a higher disposal rate. You have allowed their recovery at a much higher rate than what they used to get under the civil provisions through the mechanism of the civil courts, because the average recovery was never more than 15 to 20%. It was less than that only. And Lok Adalat, if my memory is correct, it is hardly 6%. So you are giving a high recovery, they are going there. Now, now if the bankers, you see, bank deposit is rather growing 12.9% compared to bank's credit 16.3%. So it is your good job that you are helping in the nation building.
Mr. Sir, I have one small query. Can I ask? Sir, as rightly said, like, we have been discussing about, like, which cases, which assignment to take and which not to. So like, my small query and concern is, suppose I don't take up an assignment. Okay, just saying that complexity of the nature of the assignment, like, in the situation where existing IRP is not willing to take up the case as an RP or doesn't want to, continue. So suppose somebody refuses. So what would be the status of that particular case? And number one. Number two, suppose, because see, the process has to run. There will be some IP sooner or later to, run the process. Suppose I don't give my consent, or my other fellow colleague doesn't give the consent. So, anybody, any honorable adjudicating authority may appoint somebody from the impanelment. Then what would be the situation of that?
You see, you have raised a very good question. You have raised a very good question. And once I faced this type of problem in NCLT Bangalore. In one case, if I remember correctly, because nobody was willing to take up that assignment. When I still remember, I fakely remember that when I gone into the detail of that, then I told the judicial member, because if you find the value of I'm just giving an example, by value of, there were 4-5 PCs in the office, 1-2 printers were there, that company didn't have anything. So suppose if a IP, we have appointed some IP, I suggested to the judicial member, and he was complaining that the IP is not taking up that assignment. Then I suggested, instead of going the negative side of the rule, that why they are not doing, you can ask their disciplinary authority and all other things. That is another issue. But let me tell you, what is the viability of this company? The viability of this company is, even if you sell these old PCs and printers, you may not realize even 2 lakh or 1 lakh rupees. From where the IP will get the payment? Who will pay the IP these costs? No, there is a provision that whoever has filed the case is supposed to pay. Okay, that fellow, when it was brought to the case, because it was virtually going ex parte type thing, when we asked the other party, you will have to pay the price, because if the realizable value of these assets are less, it is not a viable assignment. If an assignment itself is not viable, how anybody will take up? You have always got authority to refuse. How can, suppose if a chartered accountant, I am telling you it differently. Suppose if a chartered accountant has been appointed by the government auditor of a company, it is the duty of the government to pay the fees if the company does not have the worth. Now here it is fully blank. Here the law says whoever is the appellant will have to bear the cost time till the constitution of COC. Now there will be a cost involvement even for up till the stage of constitution of COC. Who will bear the cost? Appellant, if refuses, then that is one of the best grounds not to accept the assignment. But that should come up in writing. Suppose if you have Mr. Mahato the na ye? Ka naam
Yes, sir.
Mr. Mahato,
Yeah.
suppose you have been appointed a IP for a CD whose name is AXYZ and company. Now, if you know this company, because informally at the first instance itself, you will come to know what is the value of this company is. If you are finding that it has no money, you appear in person one day before the court and tell the court on priority, either there or through a mentioning. Suppose day after day it is getting adjourned. Then through mentioning, you tell my case be taken up. You, my lord, you have appointed me an IP from the panel. If I take the IP SIP, insolvency professional SIP of this company, who will pay my fees? This operational creditor who has filed the case is an individual, whether a cooked individual or an uncooked individual, I don't know. He is telling he will not pay the fees. I have taken these things. So, may Lord kindly release me from this assignment. No judge. Judge, first of all, should have a heart for that. If he has no heart, he has also come from a certain profession. I will not name that profession. Then it is a different thing. Otherwise, generally the judges are considerate. They will consider your case and they will exonerate you from the case. Rather, they will dismiss that case also. That
Yes.
itself is a good ground to dismiss. It is a fallacious case. But your question was very intelligent.
Thank you, sir. Thank you very much. Nicely elaborated and nicely guided, sir.
Then when all the IPs are there, because I have written about 2 years back a book on insolvency and bankruptcy. So I still remember because I have updated something. I have found one thing which I thought that I must share with you. The law so far settled on IBC. The law, the proposition of law which is settled or the developed and settled in the IBC. So I remember, and that's why I have written a few points that you all to remember firmly some of the things. I don't know if it is of value to you. I will request Mr. Sarangi, I will give this page. It is hardly 3 pages. I will send to all of you so that you can also see that suppose where the law is settled, there even diarrhea of cases is not required to be cited. Like IBC is not meant for changing payments. All of us are now aware by this time. IBC is not a debt enforcement procedure. Now, what is debt? Basically, lot of cases are filed against Bangalore की सबसे बड़ी IT company, Infosys. Lot of cases were getting filed against Infosys, Wipro, even the salary holders, because senior official salary dues itself there being more than 1 crore. So they were coming virtually for changing payments. I have been resigned. They have accepted this claim. They are not paying. IBC mentions specifically if there is a debt and default, then in that case we can always progress through IBC. Then we have to always cite Transport Corporation of Andhra Pradesh versus that case was there. I am also forgetting now with time. Now, so it is not meant for changing payments. Then it is not an adversarial litigation. It is summary in nature. Even Honorable Apex Court in recent judgment is telling that it is summary in nature. No triable issue can be adjudicated under IBC. In the bargain, then I was seeing. Now, if suppose arbitration under Arbitration and Conciliation Act, some of the issues have been decided by the arbitrator. Now the matter is pending under Section 34, if my memory is correct, under Arbitration and Conciliation Act before the confirming authority, judicial authority, say Honorable High Court. Now what will happen in that case? As IP, all of us are supposed to take care and put that amount where? Put that amount. It is a gray area. You can put in contingent claim, but in my opinion, there is a different point of view also. Don't take any risk on your head. Whether the company is sold as a resolution or the company is sold as liquidation. It may be good for that company or may be good for the nation, but at the same time, don't you yourself put yourself into difficulty. If you find that the arbitration award is there, prima facie it looks like they have covered the provisions, arbitration award is within the provisions of the contract, within the framework of the contract, when we all know basically these are the things, it is better to cover it in the claim. Let resolution applicant to take risk. Why my friends, IPs are taking risk? They should not take risk. You put it. Suppose if the gray area is there, then take benefit out and put it. Because IBI, I have seen in some cases, have unnecessarily put the member into trouble. Similarly, claims for operational must be passed on a strong foundation. there is a difference between the claims and the dues also. Claims, counterclaims cannot be a part of your admitted claims, because you cannot say whether it is correct or incorrect unless it is affirmed by any judicial authority. Balance sheet, okay, it has been confirmed that it is one of the basis on which a liability can be accepted unless it is under a qualified nature. Outstanding amounts are regarded as financial debts. Petition filed by an advocate would be maintainable. Limitation Act is applicable to the proceedings of the court. So these types of things I have written so many things. The IBC code commencement date cannot trigger point for initiation of CIRP. It is the provision of the Limitation Act which will determine triggering point for financial creditor. The CIRP process can be initiated against the government company. BHEL against, I have seen myself. Mr. Ramesh, you have some query?
Sir, I have, if I may be permitted.
No, first you tell me the query.
Yes,
because
sir.
these are the
Yes, sir.
things I will give it to
Sorry.
Dr.
Sorry.
Sarangi Saab to circulate you. Photocopy
Sorry.
दे देंगे आप लोग circulate
Can I
करें.
come in, sir, with your permission?
Correct.
I
Tell
am
me.
Ramesh here.
With
With your permission, sir. Okay. Okay. A couple of things arising out of the previous questions I posed. Recent guidelines published by IBBI stipulate that COCs must supervise the IPs. That is one. And I don't know how far this already, as I stated earlier, the IPs are subject to a lot of restrictions and they cannot take any individual decision without the support of the COC. Now, added to that is, I feel personally that this is an insult to, adding an insult to injury, where the IPs are subject to greater supervision by the COC. Second point, my learned friend, Mr. Ravi from Bangalore, from where I also hail, Mr. Ravi Devarakonda, he pointed out certain aspect where he was stating that IPs or chartered accountants or company secretaries are not really permitted to appear before the high courts. My submission, my humble submission before you, sir, and the fraternity is that wherever IPs are permitted to appear before NCLT and NCLAT, they should also be permitted to appear before the high courts or the apex court. That is my submission. I don't know how far we'll get there. The third point is with regard to the forensic audit. How do we determine where there is a doubt, where the IP has a doubt that certain transactions are indeed questionable? At what point he takes a decision whether to order a forensic audit or not? That is a practical issue. And then the second point, fourth point that you mentioned is about the recovery mechanism itself. Even the latest case of the Byju's, the Think and Learn Private Limited of Bangalore, which is drawing a lot of eyeballs all over the country because of the football, the nature of the football game that is being played before different forums. Now it's a matter before the apex court, and whether we should go with the insolvency or not is the big question now. So that is the how do we overcome the situation of preventing the IBC from being misused as a recovery mechanism. Final point, proportionate penalty where IPs are subject.
Sorry, 1 minute. Preventing IBC from?
Preventing IBC from being misused as a recovery mechanism. What I was stating, respected sir, is that despite the professed judgments of various honorable courts, it has been, taking the example of Byju's itself, They were allowed to make a private settlement despite commencement of CIRP proceedings. Now, how does this come? How does this align with the objectives of IBC as in letter and spirit? It's right that I agree with the Apex code that they have put a hold on it. I'm not sure of the latest order of the Apex code. But if insolvency is to continue, then I think they would have preserved the objectives of IBC. If not, I think there is something which we need to ponder over. Am I clear, sir?
Can I answer? Because you have raised
One final point is proportionate penalty where IPs are subject to disciplinary proceedings. Wherever there is a misconduct, established misconduct on the part of IPs, there should be proportionate punishment. It should not be that IPs must be taken away. Licenses must be taken away or cancelled, unless there is grave misconduct or where there is mens rea or a criminal misconduct. I don't think their right to livelihood should be snatched by the IBBI. Sorry, sir, I took your time.
No problem.
I take your life.
You
Thank you
have
very much.
raised 3, 6, and 7 questions. So I will be answering your. I will try to answer if my knowledge permits me. First of all, RBI, Reserve Bank of India, is a supervisory body for the banks or is a regulator for the banks. If you read the Banking Regulation Act, I don't have the Banking Regulation Act immediately here. But if you read the Banking Regulation Act, RBI is to regulate the banks. Their directions are applicable to the banks. Now, how they can ask a third professional body that they will report to the COC, that is, they will report to their members? I don't know. It is a constitutional provision, okay, because they don't have that power which the Honorable Apex Court has under Article 141, if my memory is correct. Article 141 nikalna. Article 141 nikal den. Article 141 of the Constitution provides that the Honorable Apex Court order, the Honorable Apex Court order is to be implemented by all the authorities. I don't think RBI has got that power that they can grant these types of sweeping powers to the COC that they will supervise IPs.
May I just make a correction there? Sorry, it was IBBI. I mentioned that IBBI in its latest guidelines, they have suggested that COCs must be given powers to supervise. The actual word used is supervise.
Brothers,
And it's
one thing
IBBI.
I will tell you, if IBBI has given this power, if IBBI has given this power through some regulatory format, then we are unable to help you. Only one thing as a professionals, you must take up with your regulator that why IBBI is feeling itself so inferior that they are allowing RBI to come in their jurisdictional this thing. Because in my opinion, if IBBI has issued such order through an amendment in regulatory powers, then it is very unfortunate. Because COC is not supposed to supervise. Can you tell me, as a CFO, I am or Director Finance, board can supervise me because I am internal to the management. Here, IP is virtually an external man who has been brought into the chair to either ensure two things, either the resolution for the company, or if the company is unable to restore itself, then it is to go to the liquidation. So in my opinion, IP is an external professional and their regulator is IBBI, but IBBI should normally should not should not undermine itself to his own professional brothers and sisters, because it is
I'm
unfortunate.
only concerned, respected sir, that IPs already they are subject to a lot of guidelines. As I stated earlier, at the cost of repetition, what I'm saying is IPs are already subjected to a lot of restrictions. They don't have any independence whatsoever under the code. Secondly, on top of that, if IBBI comes out with a guideline making it it's not mandatory actually. It's a guideline, cannot be mandatory, but advisory in nature for the COC to take supervisory control, which means that you're taking away the last vestige of the powers of an IP under the code. It's very unfortunate. An IP is getting reduced
I
to
agree.
being mere a rubber stamp.
I agree, Mr. Ramesh, with you that IBBI is committing a blunder by allowing this power, or by assigning even a directorial nature thing to the COC. Even if it is not mandatory, it is an objectionable issue. I endorse your view. But come to the second point, where you have told about the High Court and Supreme Court should permit insolvency professional to appear in IBC related case. You see, High Court and Supreme Court, Bar Council of India is more powerful than all other bodies. And power comes from the members. The strength of the bar, much better than any one of us. Now this is a prevalence. Now only one thing can be done. Suppose if you approach that in IBC itself, because of the constitutional jurisdictions of the Honorable High Court, and being the appellate authority in the course in the Honorable Apex Court, naturally, because 141 gives abundant power to Honorable Apex Court, law declared by Supreme Court to be binding on all courts. Now, considering this aspect, I can only suggest the best way that to sort out this issue is you to approach ministry you can go in multiple, not you as an individual, but IP as a group has to push this thing that they should be permitted to appear before High Court and Supreme Court in the IBC related matters.
Are you in agreement with that suggestion of mine,
I
sir?
agree. I agree. There is no harm, because basically what you have to know, only when you are appearing as an before the Honorable Apex Court or Honorable High Court, you should have well constitutional background, at least reasonable working knowledge of the constitutional provision, and pleadings and drafting should be there. That is the one additional requirement. Say if somebody is integrated law students, they will be in a position to do it better. If a company secretary is there, he can also do one of the best.
You can
But
prescribe guidelines to maybe make some 10 or 15, 20 years or senior professionals, chartered accountants, CMAs and CSs can do that with
I think
requisite
these,
training guidelines prescribed by
actually, basically, why it is happening now, Mr. Ramesh? Because
Yes, sir.
basically, first of all, people are not projecting the problems. Unless you project the problem will never be solved.
I'm glad that my learned friend Mr. Ravi Konda raised this issue. It's a practical issue where we find that we are handicapped.
It is a practice. Like you see under the Competition Commission of India, their Competition Act, in the Competition Act, there is a provision that a chartered accountant or any authorized representative can appear.
Yes. It's a specialized
such
field.
suitable provision, unless it is incorporated in the law, it cannot be enforced, na?
And moreover, sir, I'm sorry to interrupt you here. And even we have been attending so many seminars and so many representatives of all these agencies are there. they can also I mean, note down the deliberations and the promises and the problems being faced by us, which with due respect, we are unable to, I mean, focus on all this kind of issue and bring it on the table.
So that's why I am telling you, which I told to the Institute of Chartered Accountants of India about 5 years back. They were also on the receiving ends, chartered accountants, because everywhere they were being criticized, because like a Maruti car accident, when Maruti car newly came up in the road, wherever you go in any road, one Maruti car was lying on the roadside. So what Maruti did, Maruti uh, streamlined their production process, and at a later stage it has improved. So I suggested chartered accountant, a new government with a new manifesto has come. So not, and your colleagues, unfortunately in most of the cases, were getting involved in Jama Kharchi business. Credit, debit, doing, providing people, regularizing irregular transaction into a regular transaction. So your fellow colleagues are in difficulty because of this reason. What you have to do while you are correcting your homegrown people, you have also to tell to the government ki when the Maruti car was lying outside the road, whether we stopped Maruti car or you can take some type of relief. Now it is also happening. I am not in a position to pass comment on some of the issues, but I can only tell you that even they are crying on this issue because their professionals are in difficulty. Now they have got one more authority, that in their disciplinary authority, the number of government representative will be more than their professional members in the committee. So in this case, Ramesh Sahab or Mr. Mahato, by raising at lower level, it is not going to solve the problem. By raising it before NCLT judge, who NCLT president or somebody like this, or because there is a procedure. You
We
have
have
to, as a group, as an association, you have to represent
we
at
have
higher levels. And not only at higher levels, at all levels, all time, every moment. We
I think,
got
sir,
independence after how many years of trouble? कितने साल हम लोग गुलाम थे? We all know. So it will take time. And I am also hurt when you are telling why even I can tell you in the tribunals also, the trend was slightly different. Judicial members always wanted advocate to represent a particular case. Or they will say the client, why you are coming directly? You have to engage some advocate. And I always used to fight with him in a privacy. अरे सर आप ऐसा ब्रदर आप ऐसा उसको क्यों कह रहे हो? And that too you are telling in an open court. Why you are telling? Everybody is free to present his views. You
yes.
respect his views.
And also, sir, IPs, I feel they must come forward to represent at
IP
least.
will have to.
They have
दूसरी
been given opportunities to represent themselves before
you have
NCLT,
seen
NCLAT. They should come
you,
forward and refrain from taking services of advocates. Where they have an opportunity, they should make use of it.
I 200% endorse your views. I used to tell a youngster in Bangalore, NCLT, also in NCLAT, why you are engaging lawyers? Why? What is the necessity? But I have to be also within a restraint. I cannot go beyond a certain limit even on sitting on that chair. What I can suggest that why somebody else should represent. If you are only for doing khana puri, if you are engaging advocate, that is a different issue. But it is always, and when you engage an advocate, you cannot speak in that case. You can speak better than that advocate because you know the material content. You can
Exactly.
reply far better than the other side.
Exactly. Actually, yesterday's in one of the hearings, the court was actually saying that why are you appearing despite having engaged two counsels? He was preventing the IP from addressing the court.
You are correct. In my opinion, wherever IPs are feeling they are confident, it is always better to appear. Third thing, you have asked me another question. Force any audit, at what stage we should take up? हाँ,
Yes, sir.
आपका नाम अनुराधा, अंकिता, अंकिता तो याद रहेगा मेरे लिए, थोड़ा पानी के लिए. What I am telling you, for scenic audit, when you find prima facie that it is a like 2 years transaction, if you just go through the 2 years cash book, forget the cash book, passbook, 2 years passbook if you go, bank statement if you go, you will come to know what the company has done. Only 2 years. Because for related party transaction, 1 year case is there, otherwise it is 2 years. If you go through 2 years framework, you will come to know all these things. When you find some strong ground, then only, or a strong even a fiction in
Suspicion.
your mind. Otherwise, don't adopt this for scenic auditor. It is increasing, first of all, your cost, and at the
Yes.
same time, it is awarding you punishment.
Hmm.
But sir,
What is the
regarding-
advantage? There somebody
Correct,
will
sir.
tell why you have not taken
Absolutely, I
up
agree
for
with you.
the adjudicating authority,
Yes,
whereas
sir.
the COC is not getting approval, giving you approval. So
Correct.
both the things cannot happen together.
It's a
But sir,
tightrope
at
walk.
the same time, Mr. Ramesh, I'm just adding to your point also. Like, just traveling a little ahead. The thing is that you have to form an opinion before, taking up any
Correct.
such kind
Under
of
the code.
under
Yes.
the under the court. So
Yes.
now that we are in a dilemma, like, whether to, as you rightly explained, respected Mr. Sir, that see, लो तो भी problem, नहीं लो तो भी problem. बाद में क्यों नहीं लिया आपने? Why didn't you take action against the?
Yeah, it's all that's why I said it's a tightrope walk.
Yeah, it's a very
At
tight
what
rope.
point exactly do you make up your mind or make up an opinion to order a forensic audit or refrain from it? There's it's a high risk versus I don't know. It's
Sir, we have
probably
we have to take a
practical.
transaction audit. I think IPs are not allowed to go for
Because more often than not, I think IPs, given such a situation, they would want to err on the right side. They would don't want to take chances at the cost of being reprimanded by the adjudicating authority and being referred back to the disciplinary committee of IBBI. So they would definitely want to take a chance. So this is actually
No.
creating a dilemma. It's a conundrum for the IPs, practicing IPs, I feel.
No, I totally agree, Mr. Ramesh and Mr. Mahato. For scenic audit, if suppose some activity you are finding, when you are doing it with good intentions, and when the appropriate authority is not approving your stand, is not assisting you your stand, then it is always better to be over cautious on that subject matter. Because you see an IP who has filed a CBI case, what more he can do? His adjudicating authority can do more than what CBI can do. And then even if he gets a punishment, then why you, this is a totally gray area. It is to be resorted only when you have a strong case. मतलब अगर आपको chances में, as a finance man, I can, as a man from finance background, I can tell you, when you file the probability, and if your probability is going 60%, then only you think of. But if your probability is 10%, 20%, in my opinion, it is taking unnecessarily because
I
you
agree.
are at the तलवार के धार पर आप चल रहे हैं.
Agree, sir.
So be cautious.
And
Then
even,
you have
sir,
told about the.
Sir, even the transaction audit report is sometimes not very conclusive. Very like, IPs are being taken, in a very different way in the court.
I agree with you, because transaction audit or any such audit, auditors are to take the fees and get rid of it. They will neither confirm nor unconfirm a particular thing. Then you have to go and justify. The other side advocate will take a stand based on your petty omissions, and then that becomes IP ने अच्छे से काम नहीं किया, IP दूसरे पार्टी से ये वो. So in my opinion, these types of audit only when you go when probability factors is of high
Yes,
value.
sir. I agree
Otherwise,
with you.
your
100%.
job should be doing trading transaction or going concern and close the deal as early as possible.
Yes, sir.
Sir,
Agree.
What more he can do?
Sir, one small clarification. Suppose I have formed an opinion and I have intimated to IBBI in a CRP form. I think we have to mention that. Can I take that back?
Taking it back will have some difficulty, because Indian culture में ना हम अगर किसी का complain करके withdraw करते हैं, the law, criminal law, even the new law does not provide us with this thing कि criminal law can be withdrawn. It is a discretionary matter.
Yeah.
If
I
the
have a
court
point
अगर
here
withdraw कर देता है,
to clarify to my learned friend who asked this question. The IBC code does not actually mandate forensic or transaction audit in any of the circumstances. As sir rightly pointed out, it's a discretion of the IP. The IBC code does not really mandate transaction or forensic audit. You have to take a call, and as sir very rightly pointed out, where there is a probability of 60% of higher than 50%, where you have a doubt, then only you should embark upon that. Otherwise, you are drawing upon yourself a risk facing the adjudicating authority.
Then
Am I
next
clear?
case was that Baiju case. You have taken an example whether
Yes, sir.
Board
Yes,
of
sir.
Cricket Association, BCI, is involved, and all those
Yes,
things
sir.
are going on. Basically, it is for changing payments. Not only it is in this case,
Yes,
even Go Air, it is the
absolutely.
same problem where the
Yes.
government now issued some instruction that if they because of the international agreements between the countries, so the government issued some amendments in the regulation that if engine payment is pending, aerospace or any of its major parts like engine is pending, then they can initiate action for the recovery of the price of the engine, which was impermissible earlier under Section 14. So even
Yes, sir.
if your government itself is not in a position to take a stand, then how we can? But
Yeah.
as far as the recovery case is concerned, you can always take a stand that recovery is not the basic theme of the IBC, because IBC is telling
Yes.
what? IBC objective is very clear. They are telling an act to consolidate and amend the law relating to reorganization and insolvency resolution. Nowhere it is changing, it is for changing payments. When our code itself is not changing, that itself is one of the prime ground.
Yes,
Then
yes.
preventing IBC from being misused as a recovery mechanism. It is
Yes.
always there. Brothers, I can tell you with my experience, maybe if some NCLT member like they pass some order, I think even if my memory is correct, NHAI also, National Highway Authority of India, some adjudicating authority passed an order to go for CIRP. I was reading some newspaper, some report about 1-2 years back. Then Honorable High Court is to interfere in that case and tell it is a part of the organ of the state. So we cannot say that then it will bring emergency financial powers into operation. So they state that order. So IBC misused is there, but in any case, it is not directly affecting my friends. It is more a national issue,
Yeah.
and it is increasing the number of cases. That is one thing. This aspect is to be seen by the MCA or maybe by the government side. Now, alignment with the objectives. Objectives here, objective and recovery. The object of the code is not recovery. You have
Yeah.
already seen it is resolution or reorganization. So that is the case. Then proportional punishment. You see,
Yes, sir.
I don't know how far it is feasible. I think the members will have to take up with this IBBI. In order to bring their name fame, one should not go for resorting penalty to the professional members. Okay, I am not telling that you don't issue so-cause notice. If
Yes.
prima facie something is there, issue so-cause notice. Once you get the clarification, then you close the issue. What we do, we don't have a power also, like Benami Because when we were serving in the government, there was not a single officer against whom there will not be any benami. Particularly when he is in a promotion zone, and within 6 months of that, he will be always, so many letters will be coming against him. So it is a normal procedure you will get. Now, proportional penalty punishment, maybe sometime training, forget the proportional. We all feel in most of the cases, unless the matter is pending. Suppose if IP has violated something. Now, how it is realized that IP has violated? Because it is the fact finding final authority is NCLAT. NCLAT, unfortunately, recently what happens, it is the job of the technical members also, that whenever anything comes up against the IP, they should not immediately, because judicial officers feeling is like this. देखिए मिश्रा जी, ये थोड़ा ऐसा IP has not done. You have to convince him. As a technical member should convince him that insolvency professional have a limitation. They cannot go beyond a point.
Yes.
And so making an adverse comment on a professional, are we making adverse comment on advocates?
Yes.
Honorable High Court, Honorable Supreme Court, are they making
Exactly.
adverse comment?
Exactly, sir.
They are refraining from. Orally they may say, but it will not be mentioned in the order. Why we are doing it? It means our members also needs to be trained and tuned. So these things you all will have to take up through Dr. Sarangi here. Similarly, ICAI, BCI, all these have got their II, क्या बोलते हैं उसको? IPA. You have to take up through
Yes,
your
yes.
insolvency
The
professional agency.
IPAs, and the IPAs have to play a
Major role.
major role here. They have, for example, seminars like this where there is a lot of interaction, feedback given by professionals have to be collated into a summary capsule. And IPA has a primary responsibility to communicate to the IBBI about the concerns of the IPs. Otherwise, IPs, they will be just an extinct species after about another 5 or 10 years. I don't see a very good, in fact, they have to be playing a dominant role even above the COC is my opinion.
I agree with you. I endorse your view, but you know how chambers of commerce, actually we should have to learn from other professional bodies.
Thank you very much, sir. I am obliged for a protracted interaction, and you've been very, very clear. Thank you for all the participants who contributed.
Because why I have not taken up Honorable Supreme Court or NCLAT judgment, because all of you are more expert now than me.
Sir,
so
actually,
I thought some of the area of concern for me, which normally not people are refraining from taking, I should take up the area for the help of my insolvency professionals, brothers and sisters.
Yes, sir. Actually,
and,
that reminds
considering
me.
this only I am mentioning. If anybody has any other question, he can also ask me.
That reminds me of a former CJI, Chief Justice of the Supreme Court, who actually said that the Supreme Court is definitely supreme, but it is not infallible.
Correct. Justice Hidayatullah.
Yes. Thank you, sir.
Honorable Justice Hidayatullah mentioned that if the Honorable Apex Court judgment goes to the next higher court, 1/3 of the judgment will be reversed.
Yes. It's not infallible. Thank you very much. Thank you.
Sir, may I raise a question, sir?
Ravi, you can ask me.
Sir, actually the BCCI that whatever you're talking of the other case, no? The issue is that, sir, Section 12A withdrawal, in case of a Section 12A withdrawal, should the payment be made only to the applicant operational creditor or a financial creditor for that?
Hey, 1 minute, I missed your point, sir.
Sir, in case of a Section 12A application,
Section
12A withdrawal, withdrawal by the applicant in any case, should the payment be made only to the applicant or all the creditors? So that is actually the issue which is also coming in this Byju's problem, sir. Because in some cases, actually what the act says is that if the applicant is agreeing to withdraw, this can be the CRP can be closed. Because normally what the promoter does is the promoter makes a settlement with the applicant and closes the CRP case. But in the case of Byju's, what is happening is that even if that is done, all other creditors are also coming into picture saying that only one person is giving priority over others. So the basic problem there is that whether Section 12J can be withdrawn only by paying one applicant creditor, or should all the creditors be settled? So if your comments are on that.
No, if you read, let us read the section withdrawal of applications. Withdrawal of application admitted under Section 7, financial creditor, 9, operational creditor, or 10 is by the CD. The adjudicating authority may allow the withdrawal of applications admitted under Section 7 or 9 or 10 on an application made by the applicant with the approval of 90% voting share of the committee of creditors in such manner as may be specified. Now, manner has been provided in regulations. Correct? So, act virtually from the language says application adjudicate may allow the withdrawal of application. They have not given applications. They have only mentioned about the application. Admitted. Application admitted under Section 7. I don't know. Honorable Apex Court can always amplify the law or the objective behind it. Now, if you bear reading like NCLT and NCLAT, they will always feel that when the applicant supplies, they are to be permitted in accordance with the procedure laid down under these regulations. Now, the Honorable Apex Court is one body which can decide in a different way. Because if the company's financial condition is very bad, it is not in a position to survive. There is no hope. By paying one applicant, you cannot bring the company on a reorganization format. So they may decide in a different way. But I agree with you, as on the date, as on today, till the Honorable Apex Court amplify this judgment, it will be only that applicant fellow.
So in the case of Byju's, sir, now BCCI made an application. BCCI was settled, so it was closed. So in that sense, it is right only. Sir.
Yes, it is. That is my opinion.
It is right. BC, you all are professionals. You tell me how many cases when the other party comes up.
So the
NCLT or NCLAT dismisses the case.
The code is clear. I think if I may be permitted to interrupt, it says until formation of the COC, the settlements are permitted. I don't know the exact righteousness of permitting of the court settlements when IBC proceedings have been admitted in a court of law. Given that until the COC is formed, they have right. Parties have right. The applicant and the corporate debtor have a right to settle. It's, I think, so on that basis only, I think NCLAT also ruled against the lower court.
I agree with you. Any other questions, sir?
Yes, sir. Sir, I would like to seek your opinion on Section 9 applications.
Yes.
Basically, these applications are more on the side of a recovery kind of thing.
Sir, in continuation of this earlier question, I want to ask one more thing, sir. So, who is applicant, sir? Who is actual applicant? Suppose the operational creditor has filed an application in the Honorable NCLT. The Honorable NCLT has ordered the CRP case. COC was formed. When the financial creditor is having 100% voting rates, he has asked for the withdrawal of the case. So, who is actual applicant, sir? Whether financial creditor can withdraw the application, sir?
No. That is Mr. Goodipati. That is a matter
sir,
which your all fellow colleagues are telling. Applicant is the original person who has moved the application for this CIRP.
Yes, sir.
And the financial credit, it is not mentioning finance application. If it is under Section 7, naturally a financial creditor has moved. But if it is under Section 9, operational creditor has moved. Whoever has moved. COC has a power either to agree to the
Yes, sir.
this thing or
Yes,
to
yes.
disagree. If agrees for withdrawal, it means company is viable. All risk goes to COC. My brothers and sisters IP have no responsibility. It is the COC responsibility. Even corruption, anything will go on them. It will not come on any of you. So if they are withdrawing it, they can always withdraw.
So
If
the original applicant has to withdraw the case. Who has
the
applied?
original applicant,
Yes.
Yes.
through you, they have to go.
Ah,
See,
Procedure is
until-
clear. You, he
Until
has
the
to go.
COC is constituted, until the
But-
COC is constituted, there is no privity of contract between the COC CD. It's only between, it's a private contract between either the FC and the CD or the operational creditor and the CD. So the COC doesn't come into picture until it has been formally constituted. That's my opinion.
I agree.
When COC is constituted and COC is having 100% rights, they have recommended for withdrawal without the consent of the operational creditor who has moved the actual application.
That is
Can
different,
it be
sir.
allowed?
Operational
That is
creditors
different.
don't have a financial muscle under the IBC code. If you really
Huh?
look at the scheme of
Operational
things.
creditor who has moved the application, sir, but the COC is having 100% rights. So the 100% he has recommended for
No, again,
withdrawal of
as I said, the privity of contract is, as sir also would, as he has also been saying, that it's the absence of privity of contract would absolve the financial creditors from making an objection. You have to only, it's a trial and error. You need to
Yes.
take it up before the adjudicating authority. I don't think there are any decided cases as far as this point is concerned.
Thank
Yes,
you,
sir.
sir.
The section, the 9, the motive behind filing this section is only recovery.
Yes,
Hope you agree
absolutely,
or
yes.
not agree. I mean, behind
Yes,
the
yes.
curtains or outside.
Everyone knows, all IPs know that IBC is being misused to recover, actually being used to recover, including BCCI, if I may add, in the Byju's case. I think that is why Supreme Court has actually come down and said that insolvency has to continue. Probably, although it's only a stay order, which keeps the NCLAT's order under suspended animation. But I think the tendency of the apex court is to revive the insolvency proceedings. That's what I could decipher from the spate of judgments.
And with
so
this,
far.
with this section 9, like, many SMEs companies have been really benefited in a great way. They have got their money, like, elsewhere they cannot.
But actually it goes,
Yeah,
if you that's good, that may be good as far as the SMEs are concerned, but actually it goes against the spirit and grain of the IBC. I hope that Mr. Mishra will agree with me.
You see 9 lakh crore IBC process direct result. If you see the procedure through all these NCLT, NCLAT, prima facie only 3.36 lakh crore we have got through this. Settlement thing means with the bargaining power, the financial creditors or operational creditors have recovered 9 lakh crore through settlements. So
Yeah.
total figure of 12 more than 12 lakh crore is only because settlement is happening, and what Mr. Mahato has told is also a point. This is using a mechanism to
Yes.
bargain and get the matter settled,
Yes.
which no other law will provide.
Yes. I think we are all on a learning curve, and IBBA is also on a learning curve, despite all the judgments which say that its IBC should not be used as a recovery mechanism. But in actual practice, we have been seeing, including the Byju's case, that it has been used by the BCCI as only arm twisting, a tactic to recover its dues. So that needs to be plugged in the macro interest of the code itself. That's my submission, sir.
That I agree.
So thank you, members. Dr. Mishra, sir, if you'll permit, so we'll wind up the session today.
Correct. No issue from my side. But if anybody still has some question, I'm free to answer.
So the last question, I think, sir, if you'll take. So any member having the last question to ask? Sir? Mr. Mehdi, please mute your device, please.
Okay, since I don't see any other question, I would like to thank on behalf of the council, of course, Mr. Mishra and all the participants. I wish that all the participants take an active interest in the discussions, and it really makes it interesting when people come up with suggestions, which IPAs must definitely take it seriously. The suggestions made by honorable members who are participants, and take it up with the regulators. Thank you very much. We enjoyed your presentation very much, sir. It's been very enlightening, Mr. Mishra.
Whatever little I have the basis or knowledge I have shared with all
You are
of
our
you.
guru.
So,
Also, I have
so it
learned
is
in the
always good to
bargain.
have people like you on the dais, but that really motivates us.
No, I am always with all of you, particularly because last 7.5 years I have the opportunity of serving both NCLT and NCLAT. And
So,
that is a
actually,
good
I
luck
tell you,
to
for the
me.
past 5-6 years in the practice of IBC, now started, my legs are feeling shaky now.
No.
Just to be,
Don't feel, because even in the professional careers, graph goes up and down. This happens because depending upon even you see the administration, same police force will be very strong in some government period, and same police force will become defunct in the same government. So you never know, it goes with the time. So it is a time graph, but we have to be, now we have to be alert. There should be also job redistribution well defined. That is also not happening, because one of the IIP, some function, I mentioned about this work allocation business, because it is not uniform. It has much ununiformity. So how to make it happen is a requirement.
Somebody is
Mr. Medic, can you mute your device?
I think someone should mute his.
Sir, Medic, can you mute your device?
Prashant sir, do you have any system to mute from your?
I think you should. The coordinate moderators can mute.
Oh, so we are winding up. He has done. So thank you, Dr. Professor Mishra sir, for accepting our invitation and having a nice session. Thank you, participants, for having with us.
Thank you very much, Mr.
Thank you,
Mishra.
Sarangi sir.
Thank you.
Thank you.
Our best wishes to all of you for a happy and healthy assignment. Thank you.
Yeah, please.
Sarangiji, it was really good. I mean, appreciable that ICSI IIP thought of such a unique faculty and this manner. It is very good to learn the practical experiences of such an enlightened person. I request such similar events should be repeated.
Sure. Thank you very much. Thank you for it.
Thank you so much.
Thank you all. Thank you, Ankita, Anjali. Thank you.
Okay, thank you, sir.